Shall we start?
Yes, we may.
Okay. So, hello everyone. I'm Archie from the team of GISA Council. I welcome you all to the webinar of One Privacy Framework to Rule Them All, aligning DPDPA, GDPR, and ISO 27701, conducted by GISA Council. It is a non-for-profit organization committed to empowering individuals and organizations through specialized training and globally recognized certifications. Our mission is to strengthen the cybersecurity and IT governance ecosystem by building skilled professionals through programs such as PCI-DSS Implementer and Auditor, Associate Information Systems Auditor, ISA, CISA, CISM, Series Prep Training, ISO 27001 Internal Auditor, SOC 2 Type 2 Auditing, DPO, and many more. Our director, Dr. Hiral Patel, has over 17 years of global experience in information technology and cybersecurity. As a consultant and lead auditor, she is passionate about mentoring and guiding professionals in building successful career in information systems audit, risk, and cybersecurity. In just more than 3 years since our establishment, GISA Council has proudly trained over 5,000 plus professionals across 60 plus countries, including participants from 170 plus global enterprises with more than 30 Fortune 500 companies among them. Please note that our team will share CP certificate approximately 10 to 15 minutes before the session concludes. It is mandatory to complete and submit this form in order to receive your CP certificate. Now, it is my pleasure to introduce our esteemed speaker for today's webinar, Mr. Kiran Sawant, with over 10 years of experience in cybersecurity, information security, IT governance, and compliance. He is a seasoned professional with expertise in security audits, risk assessment, regulatory compliances. He is an approved lead auditor for ISO 27001, 27701, 42000, and 9001, and help numerous organizations strengthen their security and compliance frameworks. Welcoming Mr. Kiran Sawant as he shares his valuable insight with us today. Best wishes to all the participants. Thank you, sir. Over to you. Thank you.
Thank you for the introduction. Okay, basically, I'm from the IIT. I completed my cybersecurity in IIT itself. I work with multiple accreditation organization or the authorization organization for the different regulatory standards like 13, NCAA-IPC and all to for the data protection and the personalized data act, information security and different standards. So we will start with the session, but before starting the session, I would like to know if everyone please put their experience in data protection in a chat box so that I will get some brief about the audience experience in terms of the data protection. So we have a mix of audiences where most of the people are new to the data protection and there are few experienced professional over there. No worries. We will cater with start from the scratch and we will try to tackle with the few in-depth concept where I can support you to understand how the data fiduciary, data processor, data controller works. So I will get the brief about you will get the brief about the complete. Just confirm whether my screen is visible to all.
Yes, sir.
Okay, perfect. Okay. Now we will start our session. Before starting the session, there are few participants recently joined. I will give just a short brief about myself. I'm Kiran Sawant. Uh, by education wise, I completed my BTech and Masters. BTech in Electronics and Telecommunication. My Masters in Cybersecurity. Currently, I'm working with IIT Kanpur. I'm a auditor, approved auditor for the government entities where I supported the multiple organizations, government organization in defense sector, government organization to form the different regulations and the RBI SEBI as well. So we are today here to discuss about the mainly our focus is regarding the data protection. Data protection means what? You know that in our today's digital world, the most crucial thing is what? Data, information, and most important on top of that information is on that information PII, personal identifier information. Today, we are discussing about those things like DPDPA, Digital Personal Data Protection Act, which is formed by the Indian government act as a law in 2023. It is established, and from 2025 it is mandated by the government, so that the organization who is possessing the personal data, they should comply with this law. GDPR, General Data Protection Regulation, where this act is only applicable for the EU citizens' personal data. But that doesn't mean the citizens who is from Europe, but if they don't require, Indian companies don't require to comply with the GDPR. Yes, absolutely. Those Indian companies or the international border mechanisms who supported the European organization or handling the European organization personal data, they should comply with the GDPR Act and ISO 27701. DPDPA and GDPR are the laws, and ISO 27701 is the standard. Uh, could you please someone help me with what is the difference between law and the standard?
Hi, Kiran. Hello, everybody. So, law is something which is mandatory, which is enacted by for a particular geography or a region. Like GDPR is for Europe and DPDP Act is for India. So, it is enacted by the government and it's mandatory. While the best practice standard is the best practice, which is not mandatory to be enforced, but it's kind of a best practice.
Right, correct. Like as sir says, ISO 27701 is a standard where they have a fixed set of clauses where they are having fixed set of controls. We need to, as an organization, we need to comply. But law, by anyhow, if we are doing this thing, we need to comply with the DPDPA and GDPR by the law of regulation. Law has a penalties, but standard doesn't have any penalties. No organization can mandate ISO 27701 standard by a law, but by a geographical location, by a processing, by their business operation, law is enforced by them directly or indirectly. How this will be enforced directly or indirectly, we will discuss in a later part of the stage. But standard is not mandatory until and unless it is mandated by the your client or it is complied to the contractual or service level agreement. So I hope law and the standard difference is clear to all. Just give me so that I will get the clarity whether it is understood or not. What is the exact difference between law and the standard?
Yes, sir.
Okay, perfect, 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 perfect. Okay, now, now, okay. So that Just a minute. Okay. Now, what is our agenda? Our today's agenda for 1 hour session is why one framework matters. Like GDPR has different uh, uh, consent forms and everything. There are 19 different articles and 11 different chapters. Similarly, with the DPDPA, there are total different 7 sections, and the different 44 laws are there. As per ISO 27, 10 different clauses and different 49 controls. So we are going to check all this in a overview. We are due to time consent, we may not go to the GDPR, DPDPA, ISO 27701 in a depth, but we will try to cover all this thing in an overview manner so that all of you will get the basic understanding of GDPR, DPDPA, and ISO 27701. We are going to the core concept compared like scope, consent, right, transfer, breach, and penalties. And we are going to check how the 27701 is useful to us to map the GDPR and DPDP. So that is why our today's agenda is one framework to all the practices. Like whatever whether it is GDPR, whether it is DPDPA, or whether it is 27701. Their main motto or main agenda is to secure the personal information or the data. There may be different controls, different articles, different laws, or different sections are there, but their interpretation is in a way that it should be protect the data. There is the must first priority. On top of that, if you add a NIST as well, there are few NIST guidelines also are there to protect regarding the data protection. When we tackle with US client, there are few NIST guidelines we need to comply with. Okay. Now, learning objective. Our today's methodology or decode the terminology of GDPR, DPDPA 27701. Compare the obligation like consent, right, transfer, breach, penalties. Use of ISO 27700 between connection between GDPR and DPDPA. Design one control framework so that our work will be reduced, and the just preparing one documentation on one Excel sheet, we can comply with the multiple standards. Build an implementation roadmap, how we can implement the data security in our organization. It doesn't matter the size of the organization, scope of the organization, their business processes, structural, their geographical locations. How we can just by implementing one framework or by combining these two laws and one standard, how we can improve our data protection. These are things we are going to, and avoid common trap. Like there are multiple organizations I have seen that they work for the different, they prepare for the different documentation for GDPR, they prepared different documentation for DPDPA, and they are also prepared few different documentation for ISO 27701. But we are going to tackle how we can protect the data information by combining all these practices. Now, first, what is GDPR? What is the main objective of GDPR? GDPR stands for General Data Protection Regulation. The personal GDPR stands for it should protect the personal data of the EU citizens, protect fundamental rights of individuals of European Union citizens. Like if there are any person who is from the Europe, so that their data can be processed as per their consent, as per their controller body, as per their judiciary, so that this GDPR is generated in 2028 and it is mandated by the European board members and the European organization that any geographical location, any country who is possessing European Union personal data of their humans, they should comply with the GDPR. On same basis, DPDPA, Digital trusted building like Digital Personal Data Protection Act. It is generated by the India in 2020-23. There are 2 years of a buffer zone, and from 2025, it is going to the mandate that all the organization in India who possesses personal data, they should be comply with the DPDPA Act. Now, these two are laws. Like GDPR is for the European Union and DPDPA is for the India. Now, similarly, there is a one standard ISO 27701, which stands for Privacy Information Management System. So, that standard gives the organization an operational framework so that they can comply with these two standards and they will get certified from the organization or from the accreditation body. Can anyone please explain me GDPR, DPDPA and 27701? Where it is applicable GDPR, where DPDPA is applicable, and what is their main role?
GDPR is applicable in the EU regions. DPDPA, I think, in India.
Yes.
But rather, any organizations who are processing the data of EU citizens, they will have to comply to GDPR.
Right. Correct.
And
Okay.
standard is organizational choice, if I'm not wrong.
Correct. I will give you one example. Now, like suppose there is a one entity who is located in India, but that entity or that corporate organization supported the European Union insurance company to process the insurance related to health. So now by default, that health insurance company have the data of European peoples regarding their personal health records, their identifiable information, contact numbers, all the data which is from which the person is identified. Okay. And the third is what Indian company is just supporting that entity to process that insurance, but sometime Indian company need to that data while processing that insurance. Now in that case, does Indian company need to comply with GDPR?
Yes.
Yes, it's mandatory.
Yes, that's correct.
Yes. Correct. Absolutely. That is correct from everyone. Good to hear that. Now, whether Indian company need to comply with DPDPA?
They need to comply with the GDPR if it's the European company that they're working with because of the data movement and the visibility part of it.
No, absolutely agree with your point, Fayaz. My question is, does that Indian company need to comply with DPDPA as well?
No, not
Yes, sir.
until
Not they
unless
would be.
Yes, sir. Because by law it
No.
has to comply, sir. Yes.
I don't think so. Until unless we collect Indian company, Indian users.
Yes, absolutely. Balaji sir, I'm sorry, maybe if I pick wrong person name, but the last answer, those who given by the sirs, that is most perfectly answer, and as an auditor, that is most crucial. If Indian company who is doesn't have any Indian person's data,
Yes.
then they don't require to comply with DPDPA until and unless they have some confidential data of their own employees, until and unless they have some other persons who are working with them in India, they are also having their data as well, which is a personal identifier. On top of that, not just Indian companies personal identifier, that is a digital data. Indian company focuses on the digital trust. not on the paperwork or any other random publicly available data. No, only digitally available data, which is with the identifier as a personal identity. Yeah, Balaji sir, would you like to say something?
Yeah. So, I mean, sir, if the company employees all are related to Indian people and their data is managing by the HR, means storing the data, employees data. So they protecting their data, but they cannot process their data, right? So DPDP is not applicable, but company is processing the US based company, and so GDPR is applicable. Am I right?
Correct, correct. As per DPDPA contractual law, it is allowable to Indian companies to keep the data, but that data should be kept in an encrypted form while it is in a rest position, and the data should be stored in a secured way so that no one can access. So, as per the Balaji sir, that would be correct answer, and I'll fully agree with your statement, sir. Correct.
So those
Okay.
security controls already enforced in the ISMS as well. That is enough, right?
Correct, correct. Yeah, ISO 27 is a supporting document to comply with the data protection.
So,
Whether it
thank you.
is controller or a processor, ISO 27701 is just a feeding a support to the laws. Like as per the clause number 4, it is mentioned that the legal and regulatory or contractual requirement. That means it is by default tackled with all the agreements. Like whether it is a contractual requirement, that means if there is any contract between European client and Indian client, they mention that it should be comply with GDPR, DPDPA, and ISO 27701. Then that requirement comes under the contractual requirement. But India, that company is operated in India location, so that's why it is a legal requirement to them to comply based on their geographical location presence. But secondary, they need to comply with GDPR as well because they are processing the European data. I hope basic thing clear to everyone. Just give me a thumbs up so that I will get the clarity. Oh, thank you, thank you, thank you, everyone. Thank you, everyone. Perfect, perfect, perfect. Sure.
So does it mean that they will not have to comply to DPDPA and only comply to GDPR?
It is again, Vidyavati. It is
I
again
think
in
since they are already processing in some or the other way, they are already having their employees' data, and that is
okay.
all personal data. So do they fall under the purview of DPDPA or not?
Yeah, they will fall under the DPDPA, but DPDPA allows them to keep that data in such a way that so if they are processing their medical report, they are possessing their blood group, they are possessing their mobile data, they are possessing their PAN card, everything. But that is allowable in a DPDPA that they can keep that data in a secure way. They don't need to comply with other regulations as well. They can comply with DPDPA, but for only that section. So, but more or less, they will comply with DPDPA by doing this activity. So, both ways they are correct, like DPDPA and as well as GDPR. I hope clear.
Yes, yes. Thank you, sir.
Clear.
So, sir,
Okay.
that means as we have control in 27001 data encryption. So, if we
Yes.
comply with data encryption control, that means
Yes.
somehow we are complying with DPDP also. Is it correct?
Yes, absolutely correct, sir. I give you one example. If there are few candidates are from the BFSI sector, banking, finance, securities, and insurance, they will know that RBI says that all the data, transaction data, whether it is personal or non-personal, should be kept 7 years. But DPDPA says that those data will be deleted on that point. But what DPDPA says, data should be deleted, but RBI says data should kept 7 years. But DPDPA allows organization, if based on their business requirement, based on their contractual obligation, based on their business processes, based on their risk approach, they can comply with that law that is permitted in DPDPA. So that if we comply with this thing, DPDPA allows give a flexibility that they can give us the conformity with this thing. Yeah, you can comply with other. Is it clear? I think my point is clear to everyone.
Yeah, that means the higher requirements takes the lead. Is it correct?
Correct.
So in that
DPDPA
case,
gives.
yeah. Sorry,
Yeah,
please go ahead.
continue. I'll add.
So that means we have to keep it in for 7 years, the data, but in
First,
encrypted
go
form.
upstairs, change and put on your
Yeah,
regular
we
clothes.
we will keep that
And
data
then,
in for 7
and then
years, but we
you guys
need
will pick
to
go
apply
upstairs.
controls on that. Like data who is in a at rest position should be encrypted and should be stored in a proper like storage devices in a separate server, so that it won't be accessible
Put
to
your bed.
anyone.
You not put your bed like that. You see how your
There are
brother
they
put your
can
bed? Put your bed like
identify
that.
by this
And
thing.
then you guys pick up
I'm
all the
I'm
toys
clear.
in this room. I mean, pick up every single thing
Yes, sir.
in this
Thank you.
room.
Please go ahead.
Pick up every single thing when you get downstairs. And then
Okay.
you clean
I think
and you
Mr.
mop
Jude
the living
has
room,
to
clean and mop
mute,
the
I believe.
kitchen, microwave, make sure it's clean.
Yeah,
In
Mr.
fact, by
Jude,
the time I come
please,
back, the whole house
I
will
mute
be
don't
clean
have
and
everyone.
fine.
access to mute him.
And that's not how you make up your bed. I said, make it the way your brother. What's this here? You see this? Put
Okay,
it
we will
wrong.
continue with
Make it
later part.
straight. You see, his pillows are outside. Your pillows are covered.
Mr. Jude, hello. Will you please mute your mic? Thanks. Okay. Can we move ahead then?
Yes, sir. Yes, sir. Please go ahead.
Okay. Now, the regulatory landscape. One privacy framework matters. Like there are 144 countries, they are having their own data protection and privacy law. But there are multiple organizations, they need to comply with different laws. Like there are, I mentioned there, if the Indian company supported European organization, Indian company that supported with the US client as well, then that organization need to comply with GDPR, that organization need to comply with DPDPA, that organization need to comply with NIST framework as well. Or if in case they are handling health related data, then HIPAA as well. So it is again a what related to their, it is coming as a overlapping. But what I'm emphasizing to the most of the organization, instead of preparing different documentation, go with the one common documentation, so that that documentation will gives you access to comply with the multiple standards. Okay. Is my screen visible?
Yes, yes.
Yes, sir.
Okay. Meet the three different framework. What GDPR is General Data Protection Regulation, EU Regulation Act. It is started in 2016, but their main focus is related to the, they are having law enforcement to the their personal data, or those organization who are targeting or monitoring the EU residents' personal data. GDPR more focuses on the personal data of European citizens. DPDPA is a more focuses on the digital trust data. With the personal data which is in the digitalized form, they need to have some control, some principle based mechanism to that data. And ISO 27701 is an adaptable framework based on the organization requirement. If they would like to comply with the standard as a voluntary or based on the service level agreement or contractual requirement, they will comply with the ISO
Sir, you're not audible. Hello.
27701. Now, GDPR at a glance. What GDPR in force since 2018. GDPR adopted in 2016, and they will give a 2 years of a buffer time to the all the organization to go. Am I audible?
Breaking, sir.
Is it audible now?
Voice is
Yep.
breaking, sir.
Hello.
You're audible, sir, but your voice is breaking.
Your voice is breaking.
Am I audible to everyone?
You are audible, sir. Your voice is breaking, but
Oh, sorry.
Your voice is getting break, Kiran. Can you please check at your end?
Okay. Is it audible now?
Yeah, perfectly fine.
You're audible. It's just lagging. Yes, it is available. Yes.
And
Okay, there might be some.
Kiran sir, if you can put this in slideshow mode, that will be more better.
Okay. I'll do it. Is it perfect?
Yes.
Okay. Sorry for the inconvenience. Okay. Now, what GDPR? I'll continue with again GDPR. GDPR is enacted or the adopted in European organization in 2016, but it is enforced in 25 May 2018. They will give a 2 years of a buffer period to the all the organizations so that get familiarized with this GDPR law. Now, it is where it is applicable. It is an extraterritorial, applies to any entity targeting or monitoring European Union residential personal data. They need to comply with GDPR. Now, core actors, data subject. Data subject means like if I am the person, my personal ID, my contact details, my health reports, my PAN card, Aadhaar card, all the details are my possesses by any organization. That means I am the data subject. Whose data it is, that concept is called as a data subject. Now, data controller. Data controller means what? The middle organization who controls that data. That means if I am the person and I am having the one, I'm going to under treatment at one X hospital or at any X insurance company. What they possesses my data. At that time, these entities are the data controllers for me. And data processor. Now that health insurance, that hospital share my health reports to the some labs, some insurance companies, some different doctors, some laboratories. Then that information is processed by the some other entities. Then that entities are known as a data processor. And supervisory authority. Supervisory authority means who is authorizing or observing such a thing. If someone raise a concern regarding their data objectivity or data scrutiny, the supervisory authority have a decision whether that data is kept, whether that data process as per the consent of that person, whether the controller takes such a mitigation or implemented control so that that data won't be lost or data won't be hacked. All these things would be monitored or governed by the supervisory authority. What is the GDPR basis? GDPR has a 6 law basis. 6 law basis means what? Consent. Consent means those data is having, they should have a their consent while processing the data. Second, contract. Contract means based on their contractual requirement, their contract agreement, they should process that data. Legitimate interest. Legitimate means legal processes allows them to process that data. That is called as a legitimate. Vital means in the case of the processes based on that vital means it is a case of do or die or death of the based on that statement, they are considered as a vital. Public task, where the based on the public task, like the if suppose your only initial names or encrypted format name used or few or authentication is used, from that authentication your personal identity is not revealed, that then comes under the public task. Legitimate interest, I will explain this thing, but I won't think that will permit us a time to explain all these things in today's class. GDPR have 99 different articles, and sorry, it is a by mistakenly print one chapter, but there are 11 chapters in that GDPR. But does organization require to maintain all the 99 articles? No. Organization will required to comply with the only applicable articles. Organization don't require to comply with all 99 articles. It does not mandate by the GDPR. Okay, regulatory mode, independent supervisory authority per member state or European data protection board. Okay. GDPR now DPDPA. DPDPA is passed in someone's. May I know?
Neha, could you please mute yourself? Miss Neha. Thank you so much.
Oh. Okay. Sorry. Okay. Now we will come with the DPDPA. DPDPA is passed in August 2023. Again, in the same fashion, GDPR gives a 2 years time of adoption period or the migration period. Same way, India also gives a 2 years of a time to the all the entities to get familiarized with the DPDPA standard. Where it is applicable? Applies to the digital personal data process in India or outside the India if tied to offering goods or services to the Indian residents. So all the data possessed by the Indian entities or the outside Indian country, Indian companies, they need to comply with the DPDPA if they are processing India's data for their business processes. Now core actors like data principle. There are a terminology where the last time I said the data subject, now data principle, both are same, but the terminology is different. Like GDPR says data controller, DPDPA said data fiduciary. Similar way, significant data fiduciary. Again, what is the difference between data fiduciary and significant data fiduciary? Data fiduciary, those who are having few data of the people's personal data, but significant data fiduciary, like they are having more number of data of the personal, in terms of like they are creating lakhs of data of personal data of Indian persons or Indian residents. So that is declared by the Indian government who applies to the significant data fiduciary. They define the criteria based on how much data they are processing, they considered as a data fiduciary or significant data fiduciary. We will cover this later part, but I hope that difference is clear to you. Now, Data Protection Board of India. All these are the core actors in DPDPA. Basis, consent plus defined list, legitimate use. Now see, GDPR has a consent and all these things, but here consent plus defined list of legitimated uses. There is a completely set of instruction or sections where DPDPA allows organization to process personal data based on their few criteria. We will discuss this later part, but as an overview, we will just stick with this point. And regulator must signal National Data Protection Board adjudication, not general regulator. Now ISO 277, it is ISO 277,000. It is ISO published standard in 2019, and they are recently in a revision mode in a 2020 October 2024. Yet they are not published the revised standard, but yes, they are now complying with the new ISO 27701. Again, it is a 2713 they are mentioned, but it is ISO 2772022. So now maybe in a 1 year or of a time frame, maybe ISO 27701 new standard will be released in next year. But as of now, official standard is 27701 and 2019. Now, it is a certification management system standard. It is completely based on the organization. They, on their voluntary process or contractual required, they will comply with ISO 27701. Now, here core actors, PII controller, like PII means personal identifiable information, by which that information personal identity is revealed. PII processor, PIMS owner, certification body, those who work under the accreditation bodies to certify the different organizations. Basis, risk-based control organized as an extension of Annexure A and B. Annexure A defined as a PII control, where there are 31 different control, and in Annexure B there are total 18 control, and ISO 27701 has a total 49 controls, but all 49 controls are again not mandatory. Based on their SOS, statement of applicability, that controls are applicable. Now, regulatory mode, no regulatory third party accreditation certification demonstrated. There is no regulatory body. Completely it is dependent by the certification body, who is completely registered or having authority to certify other client based on their scope, their processes, and approved by the accreditation body. Clear? I hope basic points are clear to everyone.
Yes, Kiran. Yes.
Okay. Thank you. Okay, we will move ahead. Is it okay if I skip this part, because we are discussed already this thing, the individual GDPR has a data subject,
Yeah, sure,
the same terminal.
Go ahead.
I explained first two rows. Sure. I explained these first two rows so that you will get the big point. Sorry.
Can you just explain about this data fiduciary?
Okay.
Because fiduciary means a person where you give your data. Yeah.
The person who is having that data or personal data, GDPR has okay. Okay, data fiduciary means, sir, under the DPDPA, sir, like as we say that if there is a one X organization and they are processing some data of few persons, like there is a one insurance company and they are having near about 1,000 insurance in the company, 1,000 insurance person in the company, and they are carrying their personal data, address, nominee, Aadhaar card, their previous health reports and everything. That organization who possesses that data in terms of DPDPA, they known as a data fiduciary.
Quite.
You
there
go
is
in between and then come back. That is the only issue which is happening.
Yeah, that's true. Kiran, just one request from my side. It is great if you guys share the PPT with us on WhatsApp for the reference.
Okay, I will share with the GISA Council and their team will support you on that point.
Yeah, please do the needful for that.
Yeah,
Thank
correct. Okay, Akshay. I will do that. No issue. We will share that. Okay, sir. Okay. Parveer, your statement is regarding data fiduciary. Data fiduciary means the organization who possesses a data of different person. The organization known as a data fiduciary. Clear?
Yeah, like hospital, we give data to hospital.
Yeah,
That becomes
correct.
fiduciary.
Hospital, insurance
We
companies.
insurance. Yeah.
Correct.
So what is their
Correct. Those
duties?
who
What are the duties of the fiduciaries then? They are not
judiciary.
processing the data. Yeah.
Okay, now data fiduciary has their control over that data. Now they need to comply with DPDPA. How to keep that data, whether they are having governance policy related to the data protection, how the data is categorized, how they identified, what is the authentication mechanism they use, where they are storing their data at the time of transit, where they are consent with that person or controller. All these things they need to comply. Clear? Their roles and responsibility. There are multiple responsibilities over there, but there are 94 different points they need to comply.
Okay. And then processor are the people who are processing your data.
Processing those data, like suppose, continue, sorry.
Yeah, please go ahead.
Okay. The processor who is processing that data. That means if I admitted to X hospital, but they take my blood and send to some laboratory, in that case, I am the controller or I am the data principal in DPDPA terminology. The hospital is a data fiduciary and the laboratory treated as a data processors.
Very good. Good example you have given. So I think it will be clear, much clearer than these examples. So now we have seen fiduciary, we have seen the processor. Then what about the controller now?
Okay, controller and data fiduciary is the same terminology, but in GDPR, data fiduciary is known as a controller. If you go with the like here in terms of the GDPR, it is controller, but in terms of DPDPA, it is a data fiduciary. Both terminology are same. Similarly, the individual GDPR individual personal name as a data subject in GDPR, but in DPDPA it is treated as a data principal. In ISO 27, it is PII principal. Similarly, controller, data fiduciary, PII controller is the same terminology. I think I mentioned this thing in a previous slide.
No problem. I'm slightly, delayed person. So I have understood now. Thank you.
No. Absolutely. It is a more interactive session. I would happy to have such a question so that my knowledge also enhance. I'm in a phase of learning and educating the people, and I will much appreciate the participants like you.
Yeah, Kiran, I just want to say that I'm a, IRCA accredited auditor for 27001, 27701 and BCMS also. So I also enhance my,
22301 business continuity.
Conducting this also, So thank you. Go ahead, please.
Yeah, correct. I have work experience in certification bodies as well, sir. I work with accreditation body, NABCB, IAF as well, sir. I'm directly involved in the based on the ministry recommendation. I directly work with this accreditation bodies.
Good. So that's the reason we are listening you, Thank you.
Yes, sir. Okay. We'll move ahead, sir. so that all the participants also get the some fruitful session for today's sir. I think you are much more knowledgeable, sir. But bear with me, sir. Okay.
Kiran,
I think it is clear now.
yeah.
Yeah.
Kiran, sorry to interrupt you. The
Yes.
session time will extend or it will be complete on time because I have another meeting at 9:30.
The same way, sir. I'm also having some meeting at already line up at 10. I'll extend for 10-15 minutes, but I don't think I'll extend much more. But sir, if possible, we can
Sir, we
conclude
don't
this
discuss
session in
here.
later part as well.
Yeah,
I
yeah,
hope
sure.
you are enjoying.
You can
I
continue
hope
the session.
you guys all are enjoying the sessions. You will get the I'm not sure you will get the all clarity, but at least you will get the basic clarity of the mechanisms.
Yeah, definitely. We'll connect later on also. That's not issue. Okay, go ahead. Thank you so much.
Okay. Now again, the most thing whenever we are coming to the GDPR, DPDPA ISO 27701, where we need to have a scope and applicability. So could anyone please explain me what is meant by scope and what is meant by applicability in layman language? Not required that it should be in a standardized format. Anyone? Am I audible to everyone?
Yes, you're audible.
You are.
Yeah, anyone, please. Scope and applicability. If anyone explain me in a layman language, that would be great. And I will appreciate if someone who is new to the industry or new to this thing, if that person voluntary themselves and explain the things.
Yeah. Kiran, please share your screen.
Okay.
Yeah.
Yes. So the scope is something which comes in for the audit, right? So whenever if somebody opts for the GDPR or DPDPA ISO 27001, right? So the scope is different for there are different industries, right? So the scope is something which is not same for everyone.
Correct. Absolutely correct. Is there anyone other participant? Okay, no issue. Scope mainly depends on the four criteria. First, their business processes. Second, their number of employees, number of locations where they present, and what is their geographical presence. Scope define these things. Always in any terms, they should have this thing in a consideration. How we will consider these things? I don't think it required half an hour to explain this thing. But scope is what is the exact things they would like to comply with. Now suppose there is a one industry. I'll give you one example so that everyone can understand in a basic language. There is a one company. Does anyone recommend me any company who is in a healthcare BPO and any other organization, multiple? Suppose I give you one. Suppose like Infosys is the company. Okay, Infosys is the company which is located in a Hinjewadi phase 3 in Pune. Okay, now but in that company there is a one project which work with the European client, one project which go with the European client. Now in that case, does complete Infosys company need to comply with GDPR or only that project need to comply with GDPR?
That only project.
Correct. That
Only
means
project.
correct. Absolutely. That means the scope is only limited to the those who are supporting or those who are working on that structure. Although Infosys is a big company, but there is a small portion who is comply with the that scope. That is we called as a scope, whom it will be applicable, or what is the law criteria says, whom it will be applicable, how it will be applicable. We need to justify that thing as well. If we included in that case also, if that project is included for GDPR laws, GDPR certification or GDPR report, we need to comply, or we need to must justify that how that project comes under the GDPR law act. Not only that, we need to also explain that how other project will not come under this GDPR act. Is it clear? Whether it is inclusion or whether it is removal or exclusion, we need to explain in both cases for scope and applicability. Now, in India, as I mentioned, there are 99 articles. Do they require 99 articles? No, if they are not possessing in-depth data, they need to only comply. In India, out of 99 articles, only 37 to 49 articles are mandated to the Indian entities. How? I will explain when we are discussing the GDPR in a later part, in a more depth way. Okay, scope and applicability is clear?
Yeah, Kiran.
Okay, now lawful basis of processing. Again, I don't think I will explain this part in a zero. Okay, I'll skip this part. Cross border. I think rights of individual I'll explain later. Okay, cross border data transfer. Cross border data transfer means apart from your nation, whether it is allowable to share. GDPR completely prohibited unless valid transfer mechanism applies. DPDPA permitted the default to any country unless restricted by the government. Like GDPR won't allow to transfer their data outside the country until and unless there is a mechanism or consent in place. DPDPA permitted by default to any country until and unless is it restricted by the government. And ISO 27, there is no such a requirement. It is completely based on the recommended control guidelines, based on their legality. Approved mechanism is adequate decision, standard contractual clauses, bidding corporate, DPDPA government notification restriction, blacklisted, all these things. I'll explain this later. But okay. Now breach notification. Breach notification means what? Suppose some personal data is exposed to the real world, means public world. In that case, GDPR says notify to the regulator within a 72 hours of a time. In GDPR, they should notify to their regulatory body. In DPDPA, as soon as possible. ISO 277,000, it is completely based on that organization when that need to be the notified based on their criteria. Notify affected individual without undue delay means immediately. GDPR says that whose person data is lost, they should notify on that point only. Okay, DPDPA says that they should prescribe or inform. There is some categories again that how to inform, whom to inform, what is the regulations. And 27 again a notification template and everything. Risk threshold to notify regulatory any breach unless likely to risk, right? Matlab regulator body ko kab please mute your mics.
Mr. Deepak, could you please mute yourself? Thank you so much.
Unmute all, please.
Okay. No issue. Okay. Now risk threshold. Risk threshold means like one thing, data is lost, but there are again different kinds of data. Low priority data means what? My name is in a comes under low priority data. But if my blood reports, my PAN card, passport identity is revealed, that means the risk possesses. Okay, I'll give you one example. If my personal mail ID, bank account number, and my name is publicly available by some organization, right? They should, due to their improper control, my data is available in a publicly. But and second case, that same organization available due to their in control, my blood reports, my PAN card, my passport is available in a publicly. Which data possesses high risk criteria?
Kiran, sorry to interrupt
Yes.
you. I have my another meeting lined
Yeah,
up.
go ahead. Go ahead.
Could you just tell me your full name so that I will connect you later? And please um, request to GISA Council for sharing this session PPT and recording with us on the WhatsApp.
Sure.
Yeah.
I'll definitely.
Yeah.
But I will recommend you to just give a feedback of the session, whatever it is,
Definitely I will do
impartial,
that.
completely impartial, sir.
Yeah,
It is
yeah, yeah.
completely. What is the best feedback? You can share that feedback,
Yeah,
at
yeah.
least.
What's your full good name?
Kiran Sawant.
Sawant. You are
Yes.
from Pune, Maharashtra?
Yes.
Okay. Yeah.
I'm from Pune, Maharashtra, but I'm completely roaming right now.
Okay, great. No worries.
Okay.
Thank you so much, Kiran.
Thank you. Sorry. We'll come again. Which data possesses high risk? Can anyone tell me?
The health data.
Correct. Passport, PAN number. That means risk threshold. Which risk threshold means again? GDPR says if your data is lost, that should be informed to that person, that individual should be informed. But there is a criteria, risk threshold. What risk possesses? It should be based on their risk criteria, right? Regulatory, any breach unless unlikely to risk, right? Individual, if my only name, account number is publicly available, they don't require to mention what is the risk with my data. Then only need to notify me your data is lost and it is under the low category. But when it is in a high category, they should explain me the what kind of my data is lost, whatever it may be in a, which is defined in a GDPR as a high risk category. Is it clear?
Yes.
Clear. I'll just explain you the penalties. There is such a big slides are there, so that I prepared for you guys, so that you will get a complete exposure how to implement, how to key takeaways and everything. But I'm sorry, I won't be able to complete all these things. But I hope you will enjoy the session.
Sir, we agree that this 1 hour is not sufficient.
Yeah, correct.
There are so much to cover.
But I hope whatever we discuss, you guys are enjoyed that thing.
Sure.
Yes, so far. Yeah.
So, okay. Now we will discuss only penalties and enforcement. Okay. GDPR says 20 million euros or 4% of the company, whichever is a higher side. Like you heard the news of Amazon paid 400 crore to EU, Meta pays 400 crore to EU board. All these things just because of GDPR. Clear? I think you heard the news of Meta page, Amazon page, this fine to the European board members. This is again, they pay fine based on this GDPR law. In India, 250 crore or whichever the higher side. I'll explain. There is a calculation methodology in DPDPA as well. ISO 2770, there is no fines. I hope.
Kiran, sorry to interrupt. I have a question here.
Yeah.
For DPDP, it says if a data principal, he or she files a false statement, they have to pay 10,000 for each. Is there something similar for GDPR also?
Sorry, I won't get your question. Will you please explain again, Isha?
Yeah, sure. So in DPDPA, it says if a data principal, like if whose data has been taken, he or she files a wrong statement for any data fiduciary or processor, they have to pay 10,000 for each case. So is there any such statement for GDPR? I was curious to know.
Okay, in DPDPA as well, there is again an analysis of that data. Intentional, unintentional, there is a categories they mention. Just to no one misuse DPDPA Act for their personal benefit or their personal reputation. But in DPDPA, all the fine goes to government, not to that person. But some of the organization may damage the reputation of the organization. Like if there is a X company and someone want to damage the reputation of that company, and if there are 10 different people file a complaint against that company, in that scenario that clause is mentioned. But there is a clauses which says that how it will be calculated and everything that I will explain. In GDPR, there is no such a things.
Okay, thanks, Kevin.
Okay, is it okay, guys, if we quit the sessions?
Yes. I just had like one. Yeah, Kiran.
Yeah.
I just had one question.
Kiran sir.
Sorry, I'm bear with me. There is some network issue. I didn't hear last word.
Can you share the PPT to us? Because we covered only 25 part, right?
Okay. Sure, Balaji, I will share that. Yes, Shamim, you said something.
I just had one tricky question. Like, so nowadays a lot of companies have shifted and are doing cloud-based work, remote work. So in that case, they have multiple availability zones and all that. So how does that impact the DPDPA specifically for us Indians? Like, will the companies be fined if they are suppose their data is found on some other availability zone, let's say in US or Europe? Should they preemptively make contracts with the cloud companies to have only the availability zones in India or something like that?
Yeah, the organization can justify that we are processing the data, but we transfer our responsibilities to the SLA. But in that case, organization should do the TPRM. Organization should check their cloud environment. Organization should do the vulnerability analysis. Organization should done the penetration testing. Organization should do the pilot automation thing so that their cloud data is secured or not. Only mentioning in service level agreement won't give the organization right to not comply with DPDPA. They should justify that thing.
Okay, I got it.
Okay. Is someone from GISA Council here?
The screen is no longer shared, sir.
26 point. Yeah, Adwell, is anything from your end you would like to ask?
So can you share me your LinkedIn here in the chat? We'll connect with you.
My LinkedIn. Sure. Just a minute. Okay. I think thank you everyone. I hope you enjoyed last 1 hour 10 minutes. Just give your feedbacks, whatever it is. I'm happy to share. Suggest me the improvement points so that I can improve myself as well.
Sure, sir. Thank you. Thanks for a wonderful session, sir. Thank you.
Yeah,
Thank
Kiran,
you,
it was a
everyone.
good
Thank you.
session.
Thank you a lot.
Yeah.
Thank
Yeah,
you.
thank you.
Thank you. Thank you. Thank you so much.
Thank you. Thank you so much.
Thank you, Kiran.
Yeah, Kiran,
Yeah, thank you very
can I
much.
ask
Really
you
appreciate
something?
it. Thank you.
Hello, Kiran, you there? Can I ask you something? Hello?